Welcome to Sovereign Citizen Legal Encounters. All right, the sovereign citizen that's been trained is now back, but he's back in a different way this time. So, what I've done, I have all of his hearings here, which a lot of you like. So that way you can listen to the whole thing all the way into the end and tell what's going on in the current hearing. So, let's go in. My commentary is already there, but I'll be live in the commentary on the last one. Let's go.
This is the state of Kansas versus Quentin Lawrence Hite. It's case number 2025 TR 1215. Quentin Hite appears apparently on his own Zoom. Jaron Regier appears on behalf of the state of Kansas and the Butler County Attorney's Office. For Hite, court has an information before it which alleges in count one a charge of interference with law enforcement, a Class A non-person misdemeanor punishable by up to $2,500 fine and up to 1 year in the county jail or both. In count two, failure to register a vehicle, an unclassified non-person misdemeanor punishable by up to 30 days in the county jail and up to a $500 fine or both. What are your intentions regarding a plea here this afternoon, Mr. Hite?
Good afternoon. I do not intend to plead.
Why is that, Mr. Hite?
I have a few clerical things I'd like to clear up. Did you personally read the case filing for BU-2025-CR-000261 in its entirety?
No.
Do you believe that the filing document is true, complete, and correct?
I'm not sure why I'm answering your questions, Mr. Hite. We're here on a first appearance on a criminal case.
I am trying to clear up to make sure that the charging documents are true and correct before proceeding.
One, I never seen a sovereign citizen dressed like that. Two, he's not mentioning all caps name, straw man, none of it.
I see nothing openly defective about the charging document.
Okay,
well, let's move on. If you don't wish to enter a plea, the court will be entering a plea of not guilty on your behalf, Mr. Hite. And we'll be establishing another court date.
Your Honor, that would not be my preference. I would like to have...
Well, I don't care if it's your preference or not.
Thank you. I would like to have a probable cause hearing before a plea.
You're not entitled to a probable cause hearing. This is a misdemeanor case rather than a felony case, and you're not in custody.
Okay, I have challenges that I would like to raise on the record formally for both the case filing and the field case report from the arresting officer.
Let me ask you, do you believe that you have the financial resources to hire a lawyer to represent you in this case?
I will not be hiring a lawyer. Thank you for asking.
So you're going to represent yourself in this case, is that correct?
I will be presenting myself. That is correct, yes.
You do understand that if you can't afford a lawyer, the court will consider appointing you one.
I do comprehend this. Thank you.
But you reject either retained or appointed counsel, and you're going to represent yourself in this case, correct?
I will be presenting myself.
Very well.
Thank you.
There was an appearance bond posted in this case. Apparently, it was a cash bond in the amount of $2,000. It secured the defendant's appearance. The court has approved that bond and will maintain Quentin Hite under it, pending further proceedings in this case, which I will set.
Before that, I would like to request your lawful determination that this court has jurisdiction over this matter, as I cannot proceed until the field case report and the case filing are both verified complaints and true and correct.
I don't know where you're getting all this.
Right there on his computer screen, Judge.
According to the state's charging document, I'll advise you, Mr. Hite, that it did take place somewhere in Butler County, Kansas.
Okay, thank you for that.
I do believe it has jurisdiction.
I do have a copy of a field case report and a case filing that I received from the Butler County Attorney's Office as well as the Butler County Sheriff's Office, and I have found inconsistencies in both of the documents that I'm trying to raise here formally with you that I cannot make a plea until they have been resolved.
All right. So I've entered a not guilty plea on your behalf.
I would like to please the court that this would be not on my behalf and under threat and duress, and only under the matter that you have moved on my behalf. I have not entered a plea.
All right.
Additionally, I'd like to let the record show that due to a lack of corpus delicti via verified complaint, jurisdictional defects, and the lack of essential elements to bring a formal complaint and charges against me, I must move for dismissal immediately based on the plaintiff's failure to present all the required elements. That is in regards to the case filing. Judge, I would also like to ask, will you be reviewing the case filing and field case report in their entirety to ensure that my due process rights are not violated before the arraignment hearing begins?
The court's going to assign the case to this division. I'm going to set a court date for Monday, August 25.
And what is the purpose of that court date, may I ask?
For further proceedings in the case, Mr. Hite. It'll
Okay.
be your first appearance with following today's date. I'm going to set
Would
the
you
hearing
repeat that again?
time at 3:00 p.m. You may
My
appear
apologies.
by Zoom.
Is there an
3
in-person?
o'clock Monday, August 25 for further proceedings in this case before this court.
Thank you. And may I ask, is there an option for an in-person appearance?
Not for that court appearance.
Okay.
We'll conduct the next appearance by Zoom.
Okay. Is there an opportunity to be in person for any proceedings?
Yes.
Okay. And
But-
which proceedings would those
But
be?
what we've established today is the next one will be by Zoom. Now,
Okay.
if you don't want to appear remotely, you can come to the Butler County Judicial Center and you can participate from that location. You'll be participating by Zoom, but you can participate from the Judicial Center. So make
Okay.
sure that you have the resources available to you to fully participate in the next hearing. So Monday, August 25, 3:00, he's going to represent himself. And the court
And-
has approved and maintained him under his previously established bond of $2,000 cash.
May I also ask what
Okay,
judge
just a
and what
minute, I'm going to ask the prosecutor. Mr. Regier, is there anything else that we need to address regarding Quentin Hite at this time?
Not on this particular matter, Your Honor, although in per my duty of candor as an officer of the court, I would tell the court that there does appear to be another case involving this same defendant, where it would appear that an appearance bond has been executed for at the end of next month. I'm not sure, given the court's order, stay if the court wishes to address that matter at this time for the purposes of the judicial economy.
No. If he has multiple cases, that's the implication of having multiple cases, that he may have multiple court dates.
Very good. Your
So
Honor.
let's go ahead and cite for Mr. Hite, just in case he doesn't have it written down on his calendar somewhere. What is the next scheduled appearance in this other case?
Your Honor, the state's information is that in Butler County 25 TR 1215, there appears to be a bond, specifically a cash bond in the amount of $1,000 for an appearance date on July 30th, 2025 at 9 a.m.
All right. I'll advise the defendant that he does have a separate appearance requirement in a different case for July 30th at 9:00 a.m. I trust that would be in Zoom court with Judge Webster on that date, Mr. Regier?
That would be the state's presumption, Your Honor.
Okay, and then of course you've still got your Zoom appearance requirement in this court on Monday, August 25 at 3:00, Mr. Hite. I
Thank
think
you for
that
the-
concludes our business on
I have
the
one-
case
one
at this
further
time.
One further question, please. For this matter, the new hearing that you have just set, who is the judge and the court presiding?
The new one that I just said, you mean in this case that was before the court today?
Correct.
This judge is hearing the
Okay.
case. Okay.
Thank you for clarifying.
And if there's nothing further, the Quentin Hite matter will be in recess at this time, and we'll move on to another matter.
Thank you for your time.
Okay, now we're done with the first hearing. As you see, he's running the script a different way than the others use it. But now we're going to go into Judge Webster's court and check him out there. Let's go.
Record in, did we not do height? I thought we did.
We have not yet, Your Honor.
Oh, he's the one that didn't have his name on the screen. We're on the record in 2025 TR 1215, State of Kansas versus Quentin Lawrence Hite. Brett Sweeney for the state. The defendant appears in person and per se. Mr. Height, count one, you're charged with driving without your license and possession when demanded, an unclassified misdemeanor, a sentence up to 30 days and $500 maximum fines. And count two, driving without registration or tag, an unclassified misdemeanor, up to 2,500 in fines and 30 days to 6 months. You want to, well, how do you want to proceed, sir?
Good morning, Your Honor. My name is Quentin Lawrence Height, the accused in this matter. I'd like to briefly state for the record that I have made good faith efforts to meet with the prosecution prior to today's proceedings. I called the Butler County Attorney's Office twice and had in-person meeting times set up to discuss a dismissal agreement with the intention to obtain and present a valid Kansas driver's license, insurance, and registration on the car involved. Unfortunately, I was rescheduled on both occasions. The most recent meeting was scheduled for yesterday afternoon, but I was informed that Jared Regier had jury duty this week. At 7:55 a.m. this morning, I sent an email proposing a dismissal agreement. I also called the office at 8:19 a.m. to speak with Mr. Jared and his team, but unfortunately, Jared and both Brett Sweeney were unavailable. With that said, I am not sure if Mr. Sweeney was made aware of my meeting attempts, emails, or phone calls this morning by the receptionist in the county attorney's office this morning. Additionally, I do have a meeting set in person for August 7th at 3 p.m. for the discussion of the same matter. Given these circumstances, I request a continuance. I believe with a short amount of additional time, we may be able to resolve this matter efficiently without burdening the court. I'm also available to meet with the prosecution in person over the phone after court today or before 1 p.m. tomorrow. I'm also available to register my car on the same timeline to satisfy the diversion agreement.
Question: does this sound like he's going to register his vehicle only if they grant him the dismissal, and that's why he's trying to make the appointment to see if he registers the car, will they let it go? Let me know in the comments.
I respectfully ask the court for a brief continuance so that I may pursue this resolution opportunity directly with the county attorney's office. Thank you, Your Honor, and I yield.
All right, so are you waiving your right to counsel then and representing yourself?
I am presenting myself today.
And you understand that you can hire any attorney, and if you cannot afford to hire an attorney, you can apply for court appointed and see if you qualify?
I do comprehend, yes.
Okay, would you wish to proceed on your own behalf? Is anyone making you give up your right to an attorney?
No one.
All right, well, I'm showing that you have knowingly and voluntarily waived your right to counsel so you can represent yourself. Put that please in the journal entry and docket notes. Next, have you looked online at the diversion program to see if you are interested in that?
I have not had an opportunity to do so. As I had stated, I was hoping to discuss the terms in person with Mr. Regier, or hopefully this morning, Mr. Sweeney, but they were both unavailable. So at this time, I have not reviewed the terms, no.
Looks like you have some pending cases in about at least 2 other counties. Does that sound right?
I would like to say that those matters are separate. I don't know if that is true or correct.
Well, 2 of them are in Butler County. It looks like one in Sedgwick. Let me see when the court date is so we can maybe put them together.
And Your Honor, I was going to mention that this case has actually already been set on Chief Judge Ricky's docket for another hearing, August 25th at 3 p.m.
May I ask, Destiny, are you talking in regards to the current matter that we were discussing today, the 1215?
Yes, it's regarding this case. It's going to be set with the other case as well, though.
Interesting.
Right.
Okay.
Okay, so is Judge Ricky reassigning these 2 cases to himself?
He is, Your Honor.
Okay. Is there a felony case, Mr. Height?
I'm sorry, say again, please.
Well, I was just curious why Judge Ricky would snag 2 misdemeanors out of the group here. Do you have a felony case pending with Judge Ricky?
Not that I'm aware of, and as of my first hearing on the other aforementioned matter, he said he would not be lumping these 2 together. So this is of news to me. I was not made aware of this. And I also did state that my preference would be to have them separate, and he agreed as such. So this is interesting to me.
Mr. Sweeney, any information you might be able to have or like to shed on this?
Just kind of hearsay, Your Honor. Mr. Regier, prepping me for today's docket, did talk to me about this case and say that maybe he had a meeting coming up with the defendant, but he did mention that Judge Rickey rather took one of the cases, but my understanding in speaking with Mr. Regier is that the other case was to remain in front of Your Honor. So all of them are misdemeanors, of course, including this one. But my understanding is that he was retaining one of the misdemeanors, but this traffic case was to remain down here. I could be incorrect, but that's what I understood in speaking with him.
And I believe that was what was previously stated. I do have a note as well on this case in the 25 TR 1215 from Judge Rickey's assistant, stating that it's to be moved and set for August 25th at 3 p.m.
Okay.
All right, Mr. Height, I'm not sure what Judge Rickey has in mind, but I trust he does beyond any doubt. So we're going to move this case to Judge Rickey's docket, August 25th at 2:30.
Okay.
And license and registration. No clue, but I have plenty of cases to object. I'm grateful for any help. Let's see.
I would like to note on the record that it is my preference to keep these separate. Just wanted to make that heard.
That will be noted. Please note that on the record. An unclassified, two unclassified, you don't have to make bond in that case. So I'm going to order that you reappear at the date and time given before Judge Rickey. Did he say whether he wanted that by Zoom or in person?
My request would be to be in person. And also I did want to state one more further thing for the record that the judge had during, like I had mentioned earlier, but wanted to make sure the record reflected that he was not planning to put them together. So just making that available. Thank you.
Okay. All right, well, you may go, sir. She's from these proceedings. Just make sure you reappear at the date and time given.
Okay, and one more time for me, please. The date.
August 25th at 2:30, didn't you say, Destiny?
I show at 3 p.m., Your Honor, but
Okay.
August 25th nonetheless.
August 25th, 3 p.m. And did he say again, in person, or did he specify Zoom or in person?
I show that the other case is set by Zoom, so I would presume that both will be set by Zoom, Your Honor.
Okay, you might call back close to the date and confirm that that's right, sir.
Okay.
If you want a court-appointed attorney, you need to turn in an application for one. Do you want an attorney?
I do not.
Okay. All right. You may go, sir.
Thank you for your time.
Okay, second hearing is done. Now we're going to go into the last hearing with Judge Rickey. And let's check this out and see how this one goes. This is a good one. Let's go.
Are pending in the District Court of Butler County, Kansas, both State of Kansas versus Quentin Lawrence Height. They are case numbers 2025 TR 1215, 2025 CR 261. Jared Regier appears on behalf of the Butler County Attorney's Office. Quentin Height appears by Zoom, apparently still representing himself. These matters come before the court at this time for review of status. Mr. Regier, have you had any discussions or negotiations with Mr. Height regarding these matters?
Your Honor, the state understands that a plea offer had been previously advanced to my office. I cannot speak any more beyond that at this time.
All right, so I'll ask Mr. Height then. Is there a chance that these cases may be resolved by dismissal, diversion, or plea agreements reached with the county attorney's office?
I would be open to making some sort of agreement with the county attorney's office. I would continue to seek some administrative remedy, yes.
Okay, well, I'm not sure what you mean by the administrative remedy, but Mr. Regier, would it be helpful if we put you and Mr. Hyde in a breakout room to perhaps discuss the status of these two cases to see if there's some accord that could be reached?
Your Honor, based off my notes, it would appear that as recently as last week, my office had communicated with the defendant regarding a possible resolution of both these matters by plea. Based off my notes, the state understands that there has not been a successful meeting of the minds in this matter.
Well, we're going to try to get you two together today. So I'm going to recess these proceedings and let's put Mr. Regier and Mr. Hyde in a breakout room. Just have a brief discussion to see if there's any common ground that can be reached. And if not, then we'll come back and do further business.
Very good, Your Honor.
All right. So
Appreciate
we'll pause recording and broadcasting, Mandy, and let's put Mr. Hyde and Mr. Regier in a breakout room. Following a brief recess, the court resumes in the Quentin Hyde matters 25 CR 26 TR 1215. Mr. Regier, Mr. Hyde appearing as before. Following this conference, which the court initiated, is there any announcement to be made regarding resolution of one or both cases, Mr. Regier?
Your Honor, the state understands that my office has again offered a resolution to the defendant. However, the state understands that there has not been a meeting of the minds in this matter.
Is that correct, Mr. Hyde?
I have produced an offer on my behalf as well, and so we both made offers, and yes, a meeting of the minds has not been met.
All right. I trust then that you wish to go to trial on these matters, Mr. Hyde?
Not at this time. I'm not sure if you've been made aware, but I have requested a subpoena via a precipice that I provided to the Butler County Clerk on August 14th. That was directing them to subpoena records from the Butler County Sheriff's Office with a production date of August 22nd at 5 p.m. That date has come and gone now, and I am still awaiting the subpoenaed evidence that directly affects these charges. However, via some hearsay this morning on the phone with the Butler County Clerk, I was informed that the sheriff had motioned to quash the subpoena. I'm not personally received anything in writing as of now that shows why the sheriff would want to quash a subpoena. As such, I'm moving this court to continue this matter until I've had ample time to review and respond to the quash.
I would love to see what was written in that subpoena.
What type of materials were you requesting from the county attorney's, the sheriff's office that they haven't provided?
Sure. Body camera. I can read it directly. If you can give me just one moment. It's
well, I'm just wanting to know generally, perhaps not every detail, but
yeah, I wasn't going to read every detail. I have it right here. So that would be some policy in regarding to the Butler County Sheriff's Office policy and procedural manuals, some core policy, procedural directives, training requirements, special orders, general orders, and operational guidelines, and any updates since the arrest till now has happened. Also, all body-worn camera, dash camera, and in-cruiser footage from the time of the incident, and any and all officers, some information in regards to them, as well as probable cause affidavits, and also any further information that may be deemed necessary and pertinent to my cases.
Now, I can tell you, the sheriff's office is not going to release general orders, any policy and procedures that's internal to the sheriff's office. They only going to release that body cam footage and anything related to him. And if they need to go over something, they'll testify in court. But they're not going to hand a civilian their internal workings for day to day. Not going to happen.
Did you make a discovery request to the county attorney's office to see what documents they're relying upon?
I have not at this time. I subpoenaed to the sheriff directly to receive the full entirety of the evidence.
All right. Mr. Hyatt, you're proceeding at least to this point on your own. Is it really your intention to represent yourself on these cases, or do you want an attorney's assistance?
I am not looking for an attorney's assistance.
Okay, well, the court doesn't advise you to represent yourself in court for several reasons, Mr. Hyatt. Lack of legal expertise is one. Representing yourself requires a deep understanding of the law, which isn't always available to someone who's not law trained. Second of all, you might be prone to make emotional decisions that would cloud your judgment rather than to make rational decisions driven by logic.
3, he's following law of the sovereign people, which is not welcome into a state court.
Further, procedural missteps often happen by someone who's representing themselves. Even minor mistakes can have a significant consequence, like missing a filing deadline or failing to follow proper procedure in court. Do you understand that, Mr. Hutch?
Yes, I appreciate the notes. Thank you.
Well, further, there's the potential for severe penalties. Handling your own defense can lead to severe penalties, which include fines or imprisonment or permanent marks on your record. Do you understand that?
I do.
Now let's go over that. Well, we may have already done this once, but interference with law enforcement, as you're charged in case number 261, is a Class A misdemeanor punishable by up to a $2,500 fine and up to a year in the county jail. Do you understand that?
I do.
You understand that in count 2, failure to register a vehicle, an unclassified misdemeanor, is punishable by up to a $500 fine and up to 30 days in the county jail, or both.
I acknowledge.
All right. Further, in your other case, the 1215 case, you face a charge in count 1 of no driver's license in possession, an unclassified misdemeanor, again punishable by up to a $500 fine and up to 30 days in the county jail. You understand that?
I'm aware.
And last, but certainly not least, failure to register a vehicle in count 2 in that case is also an unclassified misdemeanor punishable by up to 30 days in the county jail and up to a $500 fine, or both.
Thank you for making me aware. I appreciate it.
And I also want to point out to you that if you proceed to trial proceedings on your own, that there's usually difficulty for a pro se individual to present evidence. Certainly, legal assistance would be very, very helpful, especially when it comes to witnesses or presentation of your evidence in court. It's often very difficult for someone who's not law trained. You understand that, Mr. Hutch?
I appreciate it. Yes.
And knowing all of these things, you still wish to proceed without a lawyer?
That is my intention.
And you do understand that if you can't afford an attorney, after proper application, the court will appoint you a lawyer to represent your interests.
I am aware. However, I would like to also make it known that I am still trying to move for getting this evidence production figured out before I'm able to enter a plea. It would be inappropriate to plea without my knowledge of these proceedings beforehand. So that is why I am moving the court for the, specifically speaking on the traffic case, to move for continuance in order to be able to discuss further with the prosecution as well as the sheriff's office and the court, if necessary, to receive the evidence that I need to move forward.
That's definitely part of the script, because the other girl that he's working with, she said the exact same thing in her hearing with Judge Webster.
Mr. Regier, is your office in receipt of and or familiar with this subpoena and the motion to quash it?
One moment, Your Honor. Your Honor, I am not aware of any such document, although it would appear that a written objection to defendant's subpoena dulcis tecum and motion to quash was filed with the court last week by Butler County Councilor Terrence Hulskamp.
All right, so it's obvious to the court that he will be handling anything in relation to the subpoena dulcis tecum request, correct?
That would appear accurate based off the filings, Your Honor.
Your Honor, if I may, I do have a receipt of delivery to the court as well as the prosecution for the subpoena dulcis tecum. So I did make them aware. If there was a clerical error within the office, I apologize for that being the case, but I did do my due diligence to make all parties involved available to be aware of the subpoena dulcis tecum that I was to be served upon the sheriff's department. I'd also like to let the record reflect that I do not have a copy of any thing that the sheriff's department or Mr. Huelskamp that may have filed in regards to a whatever motion. I've like I said, I have hearsay from this morning from the clerk, but I do not have anything in writing at this time. So it'd be inappropriate for me to act accordingly as if I knew what the material had on it.
Definitely a lot of stall tactics going on.
All right. Mr. Hyde, probably some of these requests could have been handled with proper discussion with the county attorney's office. They're usually quite liberal in their turnover of documents in the case, at least anything that's within their possession.
Sure.
If we do have a motion to quash in this case, we'll need to have a hearing on that. I'm inclined to set that as an in-person proceeding on Thursday, October the 2nd.
Just one moment, please. Thursday, October 2nd. And would that be in regards to both cases or one specifically? I do want to make sure that we're there's two separate cases here, and I'd like to be able to speak clearly to both of them separately.
All right. So your request for information pertains only one of the two cases and not both?
I submitted nearly identical recipes as well as subpoena duces tecum for both of the cases. So they would have been served and compiled in very similar manners, requesting very similar records.
All right. Both of these cases are assigned to this division. They will be essentially handled together to the extent reasonably possible, though obviously it may be necessary to try the cases separately eventually. Both cases will be set for not only determination of any discovery issues, subpoena issues, if you will, but also for further determination of status and for further scheduling. So, Mr. Regier, I will need a representative from your office pending, even if County Councilor Huelskamp handles the subpoena issues. I'll need a representative from your office on Thursday, October the 2nd. And I'm contemplating 10 o'clock a.m. for that
Very
hearing.
good, Your Honor.
Fine. All right. 10 o'clock a.m., Thursday, October 2.
And
we'll
that would
sort out
be
this subpoena issue and any issues related there too.
And what are you titling this hearing again? I'm sorry.
Well, it'll be a hearing to determine whether this court should recognize and continue the county's motion to quash. Court will make appropriate rulings regarding that. And then do further scheduling and status review as to where these two cases stand. Certainly nothing precludes the parties from having further discussions to try to resolve these issues on their own. For now, it does appear that the defendant in this case has rejected any request for appointment of counsel and apparently does not have any intention to retain counsel. So he'll be representing himself at this juncture, despite the court's admonition and warnings otherwise. So 10 o'clock, Thursday, October 2, Courtroom B, Butler County Judicial Center, El Dorado, Kansas. The
Very
county
good.
counselor's office will be so notified.
Judge, I do have one further matter, if you just one moment, please. And also in regards to the subpoena, I have been in discussions with the Butler County Sheriff's Office, and they have been quite receptive to my discussions in regards to evidence production from this case. I wanted to make you aware that I have been in discussions with them as well as the prosecution in the limited capacity that Jared and I have been I'm just making you aware so that it may be clear that I have been working outside of the court as to try and not burden the court for these hearings. Initially, I'm trying to seek remedy, as I was mentioning earlier, outside of the court, and that would be my intention. So just trying to make you aware of such happenings.
Who have you been discussing these matters with at the sheriff's office?
I have received information from I'm not sure of their title, but the administrative person at the front desk.
Eh?
Well, probably the person that should be your contact person at the sheriff's office at this time should be Terrence Hulskamp, the county counselor. He does represent the sheriff's office interests in matters such as this, and I think he's the one that actually caused the motion to quash to be filed. So you probably want to deal with him.
May I have his name, spelling of his last name, as well as contact information if someone has it available?
I don't have his contact number available, but I can spell his name for you.
I will
His
take
last
that.
name is Hulskamp, Huelskamp. I think that's what it is.
And he is the, do you have a title as well?
He's the county counselor.
County counselor.
Yes. He's obviously a lawyer.
Yes, thank you for that. Okay. I am in receipt of spelling of the last name and his title. I will, I suppose I will call the attorney's office to try and receive contact information for him and continue the discussions with him. I hope to be in receipt of any filings that were mailed to me on behalf of the sheriff and/or prosecution via the court in the next in the coming days, and review as such.
All right. And you do understand, Mr. Height, that you'll need to be in the courtroom, courtroom B, Butler County Judicial Center, for this next proceeding.
Courtroom B,
B.
and is that B as in boy?
Correct.
And is that available to me via the main entrance, and then I'll be directed as I get inside?
Yes.
Okay. I'm just trying to be clear about everything, make sure there's no hiccups.
You'll have to check in through security
Okay.
desk, and they'll tell you where you need to go. If you don't know, they'll show you the way.
I appreciate that. Okay.
Mr. Regier, anything further from the state's perspective at this time?
No, Your Honor.
Okay.
Now we're going into the most recent hearing where Mr. Height is now not free, but he's in jail. So we're just going to check out this hearing, see what's going on, and see what comes up next. Let's go.
Both in the Butler County District Court, entitled State of Kansas versus Quentin Lawrence Height. It's case number 2025 TR 1215 and 2025 CR 261. Jared Regier appears on behalf of the state of Kansas and the Butler County Attorney's Office. William Peterson as defense counsel. Quentin Height appears from the Butler County Detention Facility Zoom location. Court will review. This matter last came before the court on October 21, 2025. At that time, a hearing was conducted primarily on discovery issues. The court made certain orders of turnover of reports and materials. The court granted no relief otherwise on the subpoena quash order that the court had earlier made. Court then proceeded to take up a request by the defendant to continue the jury trial, and that was granted. The case was reset for jury at December 10, 9:00 a.m. with a pretrial conference established December 3 at 4:00 p.m. That time it was announced that the pretrial conference would also be in person. The court reaffirmed its bench warrant bond forfeiture no bond hold order due to the defendant's failure to appear previously.
They picked him up fast because other jurisdictions, sovereign citizens seem to be able to hide out for years.
The defendant was placed in custody with a no bond hold. Court set a discovery compliance review hearing for today by Zoom, and court, of course, contemplated the defendant would participate from the county jail. Subsequent to that hearing, apparently Mr. Peterson has been retained to represent this defendant in both cases. Is that correct, Mr. Peterson?
Yes, it is, Your Honor.
It's interesting how he's using the same attorney as his partner, who was a trained sovereign citizen, is using.
Ms. Leslie recently retained me to represent her, and when I say recently, that was just over the weekend, and I entered my appearance on Monday the 27th.
Now, at first, I thought maybe it was just her that changed, but he changed too. So I don't know where the change of heart come from, where now all of a sudden they want representation, but maybe they finally figured out the sovereign citizen tactics are not going to work with the court.
They locked me up for standing on my rights.
You spoke truth in their court, but truth doesn't live there.
Then where does it live? only where men remember they're free.
All right. Is there any progress to announce regarding case disposition?
Yes, Your Honor. There has been in my short time on this matter. I've had a couple of discussions with Mr. Regier, including a phone conversation yesterday in which we talked about previous plea discussions and that my client did inquire about diversion eligibility here. Mr. Regier referred me to their rules, which my reading, I don't think there's anything in there that precludes an offer of diversion if Mr. Height applies, which he would like to do. Also, Mr. Regier did send over an offer in regards to resolving this matter that my client and I have discussed briefly, and I believe that it also has, well, it's something we discussed as being able to, it's amenable to my client, I should say. But again, the diversion option is something that he would like to also look into. So at this point, Your Honor, we're prepared to let the court, set aside any future or any discussion on discovery compliance or any further discussion on the motion to quash, and even take the matter off the trial calendar if the court's inclined to do so, and allow my client to decide which of these two routes he'd like to go.
Oh, he's done enough deciding. But let's see how the court's going to feel about this.
As previously announced, Mr. Peterson, I do have a pretrial conference set December 3rd at 4 o'clock. I could convert that to Zoom, but the court wouldn't want this case or these cases to fall off the calendar. If the defense is specifically requesting I take it off the jury trial docket, I will, but I would want to leave the pretrial conference setting if you're available. Mr. Peterson, your availability by Zoom, December 3 at 4 o'clock?
Yes. And my hesitation, Your Honor, I was going to request that in person because Zoom is not our favorite thing to do. And what I mean by that is I'm in Topeka. Mr. Height is down there. We've got to travel to be in the same room anyway. And for other reasons, we prefer a in-person hearing, which...
Well, Mr. Peterson, I tried to do that as an accommodation to you.
I appreciate that.
If you want an in-person hearing, I think that's how it was originally set.
Yes.
And the court can maintain that as an in-person. All right. December 3, 4 o'clock. The court will essentially set it for a pretrial status hearing. And I can remove this case off of the jury trial calendar for the December 10th date at counsel's request. Is that what you're asking the court to do, Mr. Peterson, specifically?
Yes, Your Honor.
Very well. Court will make that order. All right. With our next court date set and the matters that have been announced, is there anything else that we need to address at this hearing, Mr. Peterson?
Your Honor, I did file a motion to set aside the forfeiture of the bond in both of these matters. And I
We
was
may
wondering...
proceed further on that motion if you desire, Mr. Peterson.
Yes, I would like to be heard on that. As I stated in the motion, Your Honor, Mr. Height is asking the court to set those forfeitures aside. A couple things I would just add from the motion, and I think it did include Mr. Height doesn't have a lot of experience with the criminal justice system, and he did, as you're aware now, heed the warnings of the court to hire counsel, get some assistance. He's done that, and I think moreover spent the last couple of weeks in a lot of self-reflection and thought about how to handle these types of situations and how to handle this current situation. And he is, like I said, taking steps to rectify this and make sure he's never put himself in this type of position again.
I wonder if him sitting in jail is the reason why he's thinking about all this.
I think that the court's forfeiture of the bond and him sitting in jail has shown Mr. Height the ways of, it's important to always adhere to the court's rules, adhere to procedure, and is asking the court to allow him an opportunity to to show that he can do that. We have an in-person setting, engage in discussions. He's taken steps to rectify, what the registration offenses, as I put in the motion, prior to being placed in custody. And again, back to his very limited contact with the court system and law enforcement previous to these two cases. I think Mr. Hite is in a position where searching for a phrase, but learned his lesson is this kind of one that jumps out at me at this point. So he is asking the court to, in the interest of justice, and these, they're misdemeanors. He's aware of, what he's accused with and the very serious nature of interference with law enforcement. And but he'd like an opportunity to show the court that he can do this without, move forward without being in custody and resolve these matters.
Very well, Mr. Peterson. I am familiar with the contents of your motion to set aside bond forfeiture previously filed. Mr. Aguirre, on behalf of your office, what is your position regarding this request?
Your Honor, with all due respect to the court and counsel, the state's position is the court's prior order should be maintained. These are two cases where the court found the defendant disregarded the orders of the court and failed to appear for a critical in-person motions hearing on October 2nd, which the state does consider troubling, especially since the defendant filed multiple demands for in-person hearings in both cases in July. It would appear that between the October 2nd and the October 21st setting, rather than submitting himself to the authority of law enforcement, the defendant filed 3 separate motions in each case, 6 total in the aggregate. And it is the state's understanding that it was only through extraordinary measures taken by third parties that the defendant successfully appeared in court during the October 21st hearing. The state further understands that this court heard argument on the issue of bond at the October 21st hearing, and it would appear that the arguments raised by counsel for the defense in the motion are largely similar, if not identical, to the same arguments raised at that setting. And at that setting, the court did find that a cash or professional surety bond was not appropriate in either of these cases. Based on the procedural history of these cases, it does appear that this is a defendant who's able to file a number of motions and subpoenas and to retain private counsel, but not to appear in court when ordered. And the state is not aware of any new information which might reasonably justify the modification of the court's prior orders. So the state's position is the court's prior order should be maintained.
I don't know how Mr. Regier remembered all of that because it did not look like he was reading from a screen. Mr. Regier is the truth.
Mr. Aguirre, you make some good points and you articulate your position well. However, I think there has been one material change in the status of this case, which this court should take into account, and that is counsel's involvement, which was not present previously, which in the view of the court would help to cut down any of the what the court would deem communication issues that we've experienced in the past regarding Mr. Hite and his cases. But before the court makes a ruling in this case, Mr. Peterson, the court has several conditions it would impose. Number one, I want a statement on the record right now from Mr. Hite as to where he will be residing. And I don't want a P.O. box. I want an actual street address where he is representing to this court is his residential address.
The address that is on my driver's license is current, the 512. I do have a question. This is being...
All right, Mr. Hite, let me back up a minute. I hope you're just not playing word games. I want to know where you're actually going to be staying. I don't care what's on your driver's license. I want to know where you're actually going to be sleeping at night, where you're going to reside. Is that the actual residence where you live?
Yes, it is.
All right. Fair enough. You've been asked a question by the court. You have one for the court, Mr. Hite. Be careful.
I was just going to raise a concern about the live streaming and of me putting my address out onto the internet. That was all.
I understand your concern, Mr. Hite. I trust anyone who is familiar with the internet could probably locate that address if they wanted. All right, the second requirement, Mr. Peterson, and it's a simple one, and that is this court would require as a condition of bond or your agreement, Mr. Peterson, as counsel in the case, to confirm in writing after each court appearance the date, time, and location of Mr. Hite's next appearance and confirm that with your client in writing. I would need that commitment from you.
Absolutely, Your Honor. Standard of practice.
Indeed. Indeed, it should be. You'd be surprised, however, Mr. Peterson, how many attorneys these days do not do that.
I understand.
Thank you for that commitment, counsel. I'm satisfied. I think that some of the problems we've had in the past have been adequately addressed by what we've talked about today. This court at this time will, at this time, reinstate the cash bond in each of these two cases, set aside any particular order of forfeiture that might lead to judgment on bond. You're back on bond, cash bond in both cases, Mr. Hite. I will order your immediate release on these two cases. If for some reason you have other holds that we haven't discussed here, I'm not releasing you from those. But in regards to the two cases currently before the court, I'm going to reinstate bonds on both with the conditions and matters that we've discussed here in this hearing. Any questions about that, Mr. Hite?
Not at this time.
All right. We have another court date set, December 3 at 4 o'clock. The court's ordering Mr. Hite, as a condition of bond, of course, to appear at that time, courtroom B, Butler County Judicial Center, for further proceedings in the case, which will be conducted as an in-person proceeding. All right, Mr. Peterson, with those rulings made, which I will expect you to promptly document through order, is there anything else from your perspective that we need to address at this time?
No, Your Honor, that has covered everything I have.
I think there's been certainly some discussion here about some matters being resolved by more or less agreement. I would hope that that will be moved on quickly so that there can be an appropriate announcement made on December 3, at least regarding the progress of those matters.
Absolutely.
All right. Thank you, Mr. Peterson. Mr. Regier, anything further that we need to address currently?
Not from the state's perspective, Your Honor.
Very well. I trust that there is someone from the detention facility who is hearing the court's orders and the order of release.
Yes, Your Honor.
All right. Essentially, it's reinstating of the prior cash bonds in the matter and releasing the no bond hold that was previously put on him by this court. All right. Thank you. I appreciate your involvement as well. If there's nothing further, then the Quentin Lawrence Hite matter, or both cases, will be in recess at this time, and this meeting may be ended for all.
I don't know how many months this case has been going on, but it's definitely been way too long. And it took for him to go to jail to want to get things straightened out. Now, the nice thing what they could have done, but I don't really hear them doing this out in Kansas. They could have put one of them GPS tethers on him, and they know where he's sleeping at night. The attorney's gonna have to make sure he watches out for him. Since the next hearing is an in-person hearing, we might not see it. So I'll find out. If it's there, we'll go through it. But I hope you enjoy all of the cases. I'm glad I put them together just in case we don't get to see the last one. Give it a thumbs up if you like it. I'll see you around on the next one.